really, I don't have a formal education in philosophy, but philosophy is my inspiration. I consider myself more as a legal theorist than a legal philosopher. Although I dare to suggest such a very philosophical title. But I kind of more used, it's a pity I can't present it, these PowerPoint slides, but I'll try to really to give some basic ideas. The problem is I used I tried to use some philosophical terminology to really to express some ideas which are relevant for long, you know. And then I ask myself whether the so-called moral cognitivism is possible, and what are alternatives to that, you know. And then at the beginning, I kind of make these extreme differentiations between two different approaches. And I usually do that because I try to start with extremes and try to then follow from there on. And the first idea that was established, I consider, you know, moral cognitivism or objectivism, although I don't really, I would say, perhaps I'm not aware of some nuances in philosophy itself, but I understand moral cognitivism or objectivism with that that it kind of recognizes the so-called moral facts, that there are indeed moral facts, that we have some, how to say, direct moral knowledge, that we are able to access, you know, some facts and, how to say, in a direct way, recognize them as moral. That would be, in my perspective, that would be one position, you know. And then another position would be that, and I would designate that approach to the so-called rationalists, you know. And then another very alternative position would be that of moral non-cognitivists or moral relativists, and I consider the extreme version of that in the way saying that there are no true moral facts, that we need for designated something as moral, we need to define that as moral, you know, that facts as such are morally neutral, and then we have to build a premise, you know, a separate premise designating them as moral. For example, what Hume suggested. You know. These are two extreme perspectives. For example, in philosophy, in general philosophy, you know, philosophers will correct me if this cannot be understood in this manner. So if I translate that, if I try to translate that into legal philosophy perspective, still we have moral objectivism, you know. Now, perhaps we could but you know, if
you can just continue.
I can continue. Okay. Yeah. So that would be okay. Moral objectivism, again, saying that supporting the so-called connection thesis, you know, saying that law and morality are essentially connected. Very much aware of that. And in some quite extreme version, that would say that some kind of direct moral knowledge of a fact is possible. There would be, some extreme perspective to moral objectivism. Contrary to that, on the other side of the spectrum, there will be, of course, moral relativism, supporting the so-called very known separation thesis, saying that law and morality are not connected at all. You know, there would be this extreme perspective. There is no moral knowledge of a fact per se without additional definition of that fact as moral. You know, there would be a perspective taken, for example, by exclusive legal positivism. There is absolutely no connection between, or no necessary, extreme or exclusive legal positivism would say there is absolutely no connection between these two types of legal norms. But then I'm asking myself whether some kind of middle way is possible. As an integralist, I don't like extremes. So, and I think also the time we are, how to say, we live in is, some kind of eclectic time. I consider postmodernism as a kind of eclectic perspective. And I really, first of all, when we try to discuss this situation, the so-called ontological difference, then we have to, of course, try to think about this relation between, of course, is and ought, between facts and norms. And I admit, of course, that, and I don't oppose Hume and his, perspective, his suggestion, his position that no logical inference is possible from is to ought, because in order to come to moral norms, we have to, develop the higher premise of this deduction scheme, deduction formula. And but there is a trick here, because I would say could be one possibility, but that could be ascribed more to what can be called instrumental or empiric rationality, what was in Latin called ratio. Perhaps in scholastic philosophy they made this distinction between ratio and intellectus. Of course, there are no moral facts, only moral norms exist, and this would be like some kind of typical dualism in, for example, or in philosophy, or ontological dualism. But on the other hand, admitting that that premise, I'm not really, satisfied with it, and which was the case that I tried to develop another premise which is important for some kind of middle approach to moral cognitivism. I would say that we can access some moral knowledge of certain facts, but that we do that through another kind of rationality, and that is, in my perspective, intuitive rationality. Because, like probably as some of you already know, I kind of follow what Carl Gustav Jung was working in his philosophical, psychological findings, that we have actually two kind of perceptions. And one is perception of facts, another one would be, for example, perception of. We access knowledge through two ways. One way is through our senses, another way is through intuition. You know? And then, of course, we could refer here to some philosophers very known, for example, Bergson, and the way he was perhaps writing about scientia intuitiva, and on the basis of such, even Aquinas could be used for that purpose, and through that we could find a way to the conception of moral facts. That is like one position. But then, on the other hand, such moral fact is limited. There would be, to some extent, referred what Professor Sayama was saying about this generality of norms itself. That when you go into details, you have problems. That would refer to moral facts as such, of course, and I guess we can access some kind of moral knowledge about certain facts, but to some limited extent. I would say to some core knowledge of certain values. One example of such moral facts would be the so-called mala in se. That it is like obvious evils. And this distinction, which is quite common in criminal substantive law, between mala in se and mala cogita. Then we can access some core of moral knowledge through intuitive rationality, but then for derive that moral knowledge further, we need some kind of what is sometimes called instrumental rationality. And I would say I use that this kind of expression of penumbras for certain areas which are not, how to say, prima facie accessible, prima facie known, and then here it's not very obvious what is required in such a situation. For example, the value of life, then, for example, murder is kind of clear, I would say, a moral fact. Although there could be some objections, I'm aware of that, but these objections could be refused. But then we don't know how to punish such kind of offense, and this kind of punishment, some societies punish that, with some, I don't know, 20, 30 years, some have capital punishment, etc. Because this area is so-called, I would say, penumbra of that value. Okay, if we try to refer to some arguments for such a position, of course, if you want to find some proofs for the conception of a moral fact, we can use different methods. One would be, for example, conceptual or even logical analysis in philosophy, but there are, of course, other methods. There is historical methods of realizing that societies, have ever, how to say, prohibited such kind of offenses or felonies, for example. We find proofs in comparative law for that core of that value. Then we can even find, which is kind of interesting nowadays, we can even find real scientific proof in natural sciences. For example, in cognitive science, the evidence or proof about perception of some kind of morality within certain facts. These were some tests done by experimental psychologists. So also we could call this kind of, even in neuroscience, you know, there are proofs of that, how to say, some kind of innate basis of a sense of justice, you know. So we could also, in this sense, we could speak about, for example, of some kind of intuitive moral lawyers, so to say, you know, that this is a fancy expression, but it shows that some kind of intuitive rationality is possible, but it's on the other hand limited to some extent, of course. For example, there is a book by Professor Mikhail, Elements of Moral Cognition, which was, I guess, published by, he's a professor at Georgetown University in the United States, and one of the proofs he is referring to the fact that even 5-year-olds can distinguish between mistakes and facts. For example, there would be, if someone shot someone because he mistook him for a tree stump, and mistakes of law. You know, shooting someone because someone believed that that was not, murder was not wrong. They would be realizing, you know, that from certain facts that there is some difference, you know, between a certain fact, whether it is, it has some, you know, connection to morality or not, you know. So, I guess realizing the fact that there is some innate, how to say, moral knowledge, you know, we would, to some extent, accept the idea of moral cognitivism, or at least some kind of moral objectivism, you know. So, meaning that we have the ability to, with certain facts, certain moral facts, referring, for example, to mala insane criminal law, referring to universal human rights, referring, for example, to some moral legal principles such as equality. But the problem with that is that, you know, even that knowledge is to some extent restricted, is to some extent limited. So we need additional norms, which are more derivative norms than, how to say, prima facie, you know, moral norms. Even, for example, and I'm not going against this Hume's and Jürgen's thesis about the separation between law and morals, but just that separation thesis is saying that this kind of connection between, facts and moral, or morality and law, is not logically possible. You know? But then we have other kind of rationality, and through intuitive, how to say, rationality, we can develop some principle. We can develop the higher premise in the deductive syllogism, of which Hume was obviously not aware. I'm not so, okay, my knowledge is limited with respect to Hume, but as I read about his separation thesis, I accept it, but I suggest some more further. I suggest some further approach to that. Even, according to some other philosophers, for example, Jacques Maritain, even Kant didn't accept intuition as some kind of rational tools for accessing, for example, knowledge. But that could be, for example, found in Aquinas and his perception of reason. Reason with big letter, with capital R, not with a small r, what we today understand as rationality, more in terms of instrumental rationality. But so, in my perspective, I would, you know, I would follow the conception of some kind of limited, moderate, or even inclusive moral cognitivism or moral objectivism. But then my next question would be, how much moral cognitivism is necessary for someone to designate him, describe him as a, how to say, as an adherent of natural law, you know, because we know that this idea or even the concept of natural law has was to some extent is kind of almost an offense today, you know, for someone, you know, to be described as a natural lawyer. You know? Even some philosophers, like I don't know, Alexei, some other perhaps Dworkin would not call them natural lawyers. You know, they would call them, for example, Alexei uses this term, inclusive non-positivists. You know, are inclusive non-positivists, which would subscribe to some kind of moral cognitivism. You know, they would not describe them as, to say, natural lawyers. And so I'm asking myself whether it is possible, in terms of modern natural law approach, to call, you know, how much this moral cognitivism is necessary within this modern natural law approach for one to be called himself a natural lawyer. You know? And I still don't have answers to that, so I hope you will help me, you know, with some of your suggestions. Okay. That will be briefly the case.